Good afternoon. Welcome to our special Facebook series called Expert Connections. We launched this series just over a week ago. As conditions started to evolve, we quickly realized that our team could help connect our community, our clients, with experts who have answers. I'm Julie Holton, founder and principal strategist of Connections Marketing Agency, where just like you, we are all feeling the impact of COVID-19. So we're helping in the best way we know how, by talking about the changes and challenges that we are all facing from coronavirus. We are so glad to have you joining us. This is definitely a time when we need to gather information from sources that we trust. Our guest today is a trusted partner of Connections. Cliff Hammond is a labor and employment attorney with Foster Swift, where he spends time in the firm's Lansing and Southfield offices. Cliff, thank you so much for taking the time to join us today.
Thanks, Julie. No problem.
Well, in just the last 2 hours, Michigan Governor Gretchen Whitmer announced what she called a stay safe, stay home executive order. And I'm sure that those of you who are watching have a lot of questions about this. You can use the chat box to go ahead and ask your questions. We will answer them as we go. So, Cliff, I want to start focusing on some employment questions. First of all, what are the obligations under the Families First Coronavirus Response Act?
Sure, it's a pretty robust statute, but when you get down to it, it's pretty simple. Really, for employers, the two things you have to know about is it gives employees a bank of time that they can use. It's additional to anything that you have currently. So if you have 500 employees or less, and that's a question that you probably have to get into with your counsel of whether you are or aren't if you're close to 500. But specifically, if you have 500 employees or less, there are about 6 different things that employees will now be entitled to up to 80 hours of leave, depending if you're full-time or not. It might be prorated, essentially, if you have an employee who works a little bit less. And they give you some guidelines in this new rule right there in the statute of how to do that. And basically what they say is if you have a state, federal, or local quarantine, like guess what, we do coming up here in Michigan, you might be eligible for up to 80 hours of leave. And there's some other things you have too. Obviously, if you have a doctor's note that says, hey, you have to be self-quarantined, that would be qualified. Obviously, you don't want the person coming to work anyway if the doctor said so. So that's not that complicated. If you've got to care for somebody who's under an order under number 1, which is the thing that we just talked about, which is a state, local, or a quarantine or something like that, an individual that you're caring for. If you have children, a son or daughter in K through 12, whose school has been closed because of an emergency with COVID-19, that's going to be covered as well, including things like childcare for maybe kids that are even younger than that, if you don't have that. And then anything else that might be covered under some sort of declaration that's close to COVID-19. For the most part, that's really what this is all about. And what the law basically says is if a person has one of those qualifying events, then you give them this leave. And they get the leave. It's before you start taking the rest of their money out. Of their PTO account, of their vacation account, the time off account. You can't substitute that. They're eligible to use that first. So that's the first, and I think it's pretty simple if you look at it from that way. The other one, obviously, I skipped over this, but I think it's pretty clear. If I have symptoms of COVID-19 and I'm seeking medical treatment, obviously, while I'm having that, I want to go ahead and get excused for that as well, and I get to use this same sick bank leave. The good news is the federal government will give you a credit for that when it comes time for taxes. So supposedly it's a zero-sum game. If you can survive and you can front the cash as an employer, a small employer, then you're in on that. The second change to the law was about the FMLA. And employers who are under 50 employees will say, what's the FMLA? And I'll tell you, well, it's this law that allows people to take up to 12 weeks of leave in a year. And it usually has some standard guidelines about how many hours you've got to work, how long you've got to work before you end. And now those things are out, and it basically says we're going to change the Family Medical Leave Act to cover everybody with 500 employees or less. And what they're going to say is if you have less than 500 employees and you have an individual who has to care for their child because the school is out because of an order like this, or their child care is out because of an order from the state or local government, or because of a COVID emergency, then you are allowed to take up to 12 weeks. And the way this works is the first 2 weeks essentially are going to be covered by the Sick Paid Leave Act that we just talked about, that new bank of time. So essentially that's out. The remaining 10 weeks that'll be out there will be paid at 2/3 of your regular rate of salary. So you take a look at what the person makes, you give them 2/3, and this is the employer fronting the bill, and you give them that money. Again, that's money that they get before they have to exhaust their PTO, their time off, or anything else. So that's also subject to a credit to allow you to essentially get the money back. But that's really what this is in a nutshell. It's an opportunity for people with very limited types of COVID-related absences and illness issues to be able to be off of work and be paid, and for the employers to get paid back. So that's in a nutshell, 30,000-foot view, what this whole statute's about.
Okay, so, and I imagine that communication is pretty important, as with all of these issues. So if I'm an employer, how do I need to be communicating this with my employees?
Well, the good news is there's this massive law that's everybody in hysteria. The bad news is we really don't have that notice yet to try to get this out to the employees. The Department of Labor is supposed to put that out. We're supposed to communicate, by the statute itself says you're supposed to notify employees of this. There's a notice that will be out and coming, hopefully fairly soon, and maybe even this afternoon, from the Department of Labor, because they're looking at a few things. They're looking at whether or not they should exempt some small employers, because there might be some people with 2 employees sitting out there going, where am I coming up with this money? There might be people that have economic circumstances, and the statute allowed the Department of Labor to issue some rules about who's in and who's out. So once we get that guidance, we'll be able to tell people. Now, you're free, if you're an employer, to give them a copy of this statute, which is available online. You can Google it up, quite frankly, find it. You look to sections D and E of the statute, and it's pretty clear what they want you to do. I mean, there's some things you might have to interpret, but who is and is not available for this leave is spelled right out there. And it's not complicated, really, once you read it. You don't really need to put a whole lot of time, but if you have any questions, obviously talk to your counsel, the representative that you have. But I think really what you need to do is get ahead of it, make sure you tell your employees as fast as you can. And quite frankly, now that we've got this order from the governor that came out this morning, it'll make it a little more difficult to get the word out. But the important thing that people need to know about is that these leaves, they actually don't start under the federal law, the paid leave portion, until April the 2nd. There was a 15-day lead period into when this comes. So interestingly enough, if you take a look at what happened today, and we'll talk about that probably here at some point, the governor is saying that most employees, unless you're in certain qualified essential services, are going to be told to stay home. And the question is going to be, well, do I have to pay them? Because that sounds like an isolation order from a state agency. And quite frankly, it will be come April the 2nd, but it's not today. So you're not required to pay now under the statute. You can, if you would like, to go ahead and start paying people whatever you want, but whether you get the tax credit or not, that's not in the statute. The statute hasn't started, at least right now, unless we get some kind of change. So you can allow individuals to use their bank time. You can pay them whatever you want to pay them, quite frankly. But these new rules we just talked about, they're not going to apply yet because it doesn't become effective until April 2nd.
Okay, so obviously a lot still needs to be worked out. And like you have said a couple of times, at least we're all in this together, as messy as it might be, as they continue to work these details out. I do want to talk about this shelter-in-place order issued today by Governor Whitmer. How does that affect employers?
It's a very big deal. I mean, there's no way around that. I mean, I'm not going to say it's a bigger surprise than Tom Brady going to the Buccaneers, but it may be, right? Okay, so let's take it for what it is. It is for everybody, right? It's across the state. It's for everybody unless you are exempted. Now, I've got the rules right here. I got the executive order here in front of me. I'm still going through that. I'm still trying to figure out who is and isn't, but what it basically does is says everybody stay at home, okay? Go out and walk your dog. If you have to go to the grocery store, that's fine. But just keep social distancing and don't talk to people, and basically don't go to work unless you're in one of these places. So that's what the order is trying to do. It's trying to keep people away that are non-essential services out of the workplace through until the middle of April so that we can try to get a handle on the spread. That's all this really is. And so most employers are going to be covered by this. And if you're not, you're really going to have to look through the statute. And there's even some individuals within your organization that might be designated. There might be essential people. And you're going to have to tell them that they're essential. You can't just make it up. So there's a lot of groundwork that's got to be done in a very short period of time. So to recap, what this order basically does is it says most companies, you can't have your employees come in to work, but you can let them work remotely if you have that option. If you don't have a remote work policy, you might want to get that rolling out here today. If you can take a day or two to get it done within your service, that's fine. If you wonder whether or not you're covered under this exemption, there's certain businesses that are out there that are not exempt, and obviously healthcare services, things like that, first responders. But if you're not within those services, there's actually a laundry list of different people in different industries that's listed in the executive order. And I would encourage employers to get onto the state of Michigan's website, take a look. They actually have a link to the Department of Homeland Services, and they basically break down what type of jobs are going to be critical services that are allowed to come into work. So you should go out there and look to see who is and who is not within your company going to be essential. And so it's very important. You can't make an executive order like this, obviously, that's going to cover every single job that everybody in the state of Michigan has. 10 million different people in the state. Obviously, that's very hard. But I think what they've done is they've tried to plan ahead of time with the Homeland Security to say these are the types of jobs that'll be critical. And everybody else, if you're in doubt, be careful as an employer trying to make them come in, because you don't want to have those individuals, subject to a sanction or a fine. And the executive order says you will be basically hunted down as an employer if you're trying to violate this rule, and we will, prosecute you to the fullest extent of the law, because this is a very serious issue. So long story short is your employees are out of the workplace, period, unless you fit the criteria that they've enumerated. And quite frankly, I'm still trying to make sure that I know who's in and who's out. In your industry, there's a lot of different industries, there's a lot of different jobs. Some may be in, some may be out. But what the governor would like you to do, and what the state has tried to say, is as a public policy, we'd like you to say, hey, can you at least work at home? Unless you're in certain industries like food production, things like that, transportation, certain jobs, certain core, services like a food establishment, a grocery store, things like that. But even within some of those industries that you might think are open, there may be jobs that aren't essential. And they would say, can you at least let those people stay at home to the extent they can? And
Absolutely.
Yeah, and as an employer, you got to figure out how you're going to pay those people. Can you pay those people? What are your policies? And I hope that most employers have essentially looked into this before now, as we saw this wave coming, but not everybody has, because you have a lot going on.
And certainly this is the first time we've ever faced a pandemic like this before. So a lot of questions and a lot of I know government's working hard to find some answers. I did find it interesting when listening to Governor Whitmer's press conference that she mentioned that restaurants, that food delivery drivers, would still continue to the extent that those businesses stay open. And so definitely employers, as you said, Cliff, should be reading and finding out who within the organization, or if the organization is still considered an essential service.
Yeah, it's critical. I think it's important, because you can't sit here on this medium right now and answer every single question. So you should talk to your counsel ASAP to find out who's in and who's out. And because that's not going to question, that's going to be, some will be easy and some are going to fit into some gray areas. But I think there are some areas, like you said, that are out there. And that's because of the reality. Look, if people aren't supposed to go to the store under this executive order, they can go to the grocery store, but they're encouraged not to. Then what's another way you can get food and supplies to individuals? Well, it's by delivery. So that kind of makes sense. It dovetails into the technology we have, the reality of society we live in. And that is a way to make sure that people that are vulnerable, or who can't get out, or we don't want them to get out, can get those services. But those people are employees too, right? Those people have to come to work. So you obviously have to have exceptions. You can't just pretend like those people aren't real people, and they are. And a lot of businesses depend on them throughout this time, and a lot of people do too. So that's why you have to look at this.
And for those who may be watching us now and did not see the news conference, this Governor Whitmer was calling it a stay safe, stay home executive order. It goes into effect starting at midnight, just after midnight tonight. So starting tomorrow, technically, and stays in effect for 3 weeks. Cliff, I want to ask you now, how does ADA and normal FMLA pay, in conjunction with these new federal laws that have been enacted, how do they all play together regarding coronavirus?
Yeah, and it's going to be another big issue. Obviously, if we had kept businesses open, not had this order, this was going to be the biggest problem with COVID-19 was You had individuals calling in, I'm sure, everywhere saying, I'm afraid. I'm afraid. I might not have a medical reason, but I'm afraid. How do you address those things? That now continues to be, but probably on a smaller scale now within our workplaces because a lot of people are going to be working from home. But the question is going to be, can you work from home? Let's just say that there's the order goes into place. You come Wednesday, you have some people that are at home. Can you let them work from home? If they say, my doctor has said I can't work for a long period of time, are you now allowed to have an accommodation that can do that? Can you say no? Can you tell them they can't work and continue to get a paycheck, instead put them on a leave of absence or lay them off or whatever you're going to do in accordance to this? So the bottom line is, what I always say is, follow the normal ADA and EEOC or FMLA guidelines that the EEOC has put out, and the cases are all there. HR professionals know what these are with respect to the personnel that is essential that you're going to designate to come in. If they say I can't come in because of, and they give a medical reason or they need a leave, we'll follow the same FMLA or FMLA EEOC guidelines, the same ADA interactive processes that you would under normal circumstances, and apply it to these facts and these circumstances. So those individuals need to be treated. The people on leave need to be treated. And you have to be very careful that you don't just throw the baby out with the bathwater and say, oh, well, the governor said you all got to go and it doesn't matter. It does matter. You still have to stop, think it through, and make sure you use the same analysis as you would in any other situation. So I think it's critical that we don't lose our heads, that we don't overreact and we don't underreact, that we just treat this as what it is, which is a potential ADA accommodation issue or a leave request. And how does your policy apply to individuals who are on either one of those two? Well, it should be consistent and even-handed in this situation as well. Understanding that there are obviously different circumstances, but every case has different circumstances, no matter what it is.
This is also reassuring to hear some of this info and to know that a lot of businesses are really, even with all of the uncertainty, a lot of businesses are going through this together. Cliff, I wonder, what about businesses that have locations in different states? Because there are, when it comes to their employees, because different states, as we know, have different executive orders or a lack of orders right now. And so what about those employees? Does an employer need to respond based on where their employees are located? How does that work?
Well, this order talks about employers and people who reside in the state of Michigan, right? So we address this one here. If you have places in Illinois, California, and New York, you're going to have to address those under their laws and their rules. So you can't apply Michigan law any day to Florida or Arkansas or wherever you do business. So you shouldn't do that with this either. It's very important to understand, if you have a complex business model, you got to be complex when it comes to these type of leave issues. And when you have a pandemic, it's going to affect you. No different than doing a contract in California. You got to have different rules of construction. You might have to have different requirements. So our governor's order is going to differ probably from some other places' order. This isn't a federal mandate. Now, if that comes down, there's a federal rule. Obviously, that'll apply across the board. But unfortunately, we live in a country that has multiple states with different laws, and we're just going to have to, make sure that we're on top of those, and we just don't let it go by the wayside.
What is something that you absolutely do not want to do until you've talked to an attorney?
We just don't want to start firing people left and right. Okay. That's the biggest thing that people say is, that's it. I'm done. I'm out of business. I'm closing the place down. Well, what if you have 100 people? All right. What if you have 100 people, you fire them all, you call it a day, and you walk away? Well, there are some requirements. There are some notices that have to go out if you have a certain number of people. And if you lay off a certain amount of people, and it causes a reduction in your workforce or reduction in hours over the next 6 months or more than 6 months. And there are federal rules about that. The same thing comes for disabilities. People say I have COVID-19 during this thing. I said, well, since you got COVID-19, and I'm just going to have to lay you off or let you go because of that. Well, that might be retaliation. If you don't let somebody work from home, but you let another person, it just happens to be one's black, one's white, one's female, one's male, you might have yourself a discrimination lawsuit. So you've got to be careful that you just don't act quickly. Think it through, understand how the operations are going to be affected, and are you engaging in a discriminatory act? Even if you're trying to keep people in work, you got to make sure it doesn't have a discriminatory effect, and an outcome that you didn't intend.
Absolutely. Cliff, thank you so much for lending your insights. Is there anything else that we should add before we start to wrap up here?
I think the only thing I would tell everybody is this is changing on a daily basis, right? If you ask you two weeks ago, will we be sitting here? No, of course not. Nobody would think we would do that. We're here. And did you think 2 weeks ago there'd be a federal law, bipartisan, that we will, have all these paid leaves and give people credits for it? Probably not, right? So that's where we're at now. We're looking at this. We hope that it'll abate, but we just don't know the timetable. And I think you have to keep on top of all the changes that are coming on. They may relax or they may make it more stringent on who you can and can't bring in. And it's very important that your notices to your employees who is and isn't essential and how they can come in and when they can come in. And you've only got until the end of the month to put that in writing. You can do it orally until then, but it has to be in writing. So make sure you do it right. And if you're thinking about laying people off, putting them on a leave of absence, terminating them, think through it and consider it very, very carefully about the long-term repercussions, not the short-term gains. Think about this as a holistic business approach, and think about possibilities and how they're going to affect you, because you don't want to get to a point where we come back to work and your employees are gone because they're mad at you. And what about insurance? How are you going to address that? So you got to think about it in a very short period of time.
Absolutely. Cliff, thank you so much. And many of our viewers have commented here thanking you for the information. I know you must be very busy going through all of this right now. So thanks for taking the time to talk with us.
Not a problem. Anytime.
All right, our Expert Connection series continues all week long right here on the Connections page. Tomorrow at 1 p.m., we will be joined by Andrew Bailey of Washington Avenue Ventures. Obviously, as Cliff just said, things are changing day to day. So we will have a lot to talk about tomorrow. In the meantime, if you have any questions, please feel free to reach out. If you have further questions for any of our guests from today or from last week, feel free to comment and we will get back to you. And check out our video tab. We had 10 live interviews last week with a variety of experts, and all of those videos are there. You can also head to mconnections.com for further resources related to COVID-19. Thank you all, and we will see you back here tomorrow at 1 p.m.